Ogoni bupirima reka ele morena kawena reka ema ratswarana morena orejoje lesedin rejoroje waar die wilgers welig spruit door een boom sy skadu sprei soos ons groei in kundigheid mag U ons lei sien ons hoe hier lei met die hand laat U sien rus oor ons land. Three strong streams united flow, Africa stands proud and tall. As we learn, we trust, we know God is in control. Bless us, O Lord, guide us with grace. May Northwest be blessed always. Bless us, O Lord, see ons lief. Ore Jehovah se morena, see ons bless us, O Lord.
Good evening, ladies and gentlemen. A hearty and warm welcome from the Faculty of Law and Northwest University. A special welcome to our one and only guest of honor, Prof Elmien du Plessis. Madam, come and join me here. It is a privilege and honor to have all of you here, friends, family, and colleagues. Today, we are gathered here to celebrate success and excellence at its best. Prof Elmien, we are proud of you as the Faculty of Law. And most of all, thank you for the contributions that you continue to make in our jurisprudence, the impact that you make on the core business of the Faculty of Law. Thank you very much. Know that we appreciate and we love you. And thank you for your humble and positive spirit that you always exude. Personally, I've always felt at ease in your presence. Congratulations. Elmien du Plessis is now a professor in the Faculty of Law at Northwest University, South Africa. She holds BA International Relations, LLB and LLD degrees from the University of Stellenbosch. She is also an NRF Thuthuka grant holder. She obtained her doctorate on compensation for expropriation under the Constitution in 2009. Her interests are diverse. She is interested in property law issues, especially in the land reform context, and the overlap between customary law and common law notions of property rights. Recently, her research started to investigate concepts of justice that underlie the Constitution and how legal interpretation can be used to concretize the values of the Constitution to attain justice. She has published numerous peer-reviewed articles and chapters in books on these topics. She has a passion for finding the human element in law. As an engaged, versatile, and balanced scholar, she is particularly interested in how law can mediate the common ground in society with a keen interest in justice. She is committed to ensuring that her research impacts the broader community in South Africa to build a just society. When she's not busy thinking about property law and its impact on society, she tries to apply property theories at home. When her 3 offspring struggle over scarce resources. When this does not work, she loves to sit under a tree and watch the blue skies through the branches. Her professional experience. 2005, she was admitted as an advocate of the High Court of South Africa. 2010, senior lecturer, University of Johannesburg, South Africa. 2014, associate professor, Northwest-University, South Africa. 2022, professor, Northwest-University, South Africa. 2020, acting judge, Term 2, High Court of South Africa. Her academic qualifications, 2000 to 2002, Baccalaureus Artium, University of Stellenbosch, South Africa. 2003 to 2005, Baccalaureus Legum, University of Stellenbosch, South Africa. 2006 to 2009, Dr. Legum, University of Stellenbosch, South Africa. Title, Compensation for Expropriation under the Constitution. Supervisor, Professor Andrie van der Walt. 2009, postdoctoral research at South African Research Chair in Property Law. Congratulations, Prof, and enjoy.
He does not want to recognize my face with his hat on. Okay. Good evening, everyone, and welcome. So, an inaugural lecture, the university's website states, is for newly appointed full professors to present themselves and the area of study to the university and the academic community. My alma mater, Stellenbosch University, states it's an opportunity to share my knowledge, scientific discoveries, and even personal journeys in my field with the public and the academic community. The Nelson Mandela University calls it a significant milestone in the academic career of a full professor. WITS is quite ambitious. It calls it a rite of passage, which for hundreds of years include the test of having to profess your knowledge to a lay audience and fellow academics. And just to make it interesting, they add the title professor comes from the need to profess or to declare publicly one's knowledge. This is, then is, according to WITS, my platform to share my brilliant discoveries, innovative ideas, and deep insights with the public and the larger academic community. You can imagine that this leaves me quite nervous. I had to find a topic that might entice the larger public, something I know enough about to profess my knowledge, but not too much, as I must also show what I plan to do in the future. And thus I stumbled across this topic, which combines my that combines my love for history and art, my knowledge of land issues, and my profession, the law, in one lecture, and to allow me some freedom to not have all the definite answers, but to touch on things I need to think about in the future. The title Land, Law, and Afrikaner Nostalgia came to me on a road trip before the content appeared. So I spent quite a lot of time journeying through this fascinating topic to present to you, my dear audience, a lecture. An intriguing book on the future of nostalgia by Boehm writes about the history of nostalgia. Nostalgia comprises two concepts: nostos, the return to home, and algia, longing. In other words, nostalgia refers to a longing home that no longer exists or never existed before. It speaks of loss, displacement, and a romance with a fantasy. The history of nostalgia is quite interesting. It's got nothing to do with law, but it's interesting, so I'm going to share it, which also is where the slide comes from. Because in the 17th century, nostalgia was a curable disease, like a cold. It was blamed for producing erroneous representations that caused people to lose touch with the present. Swiss doctors treated it with opium, leeches, and a journey to the Swiss Alps. A return to the motherland was considered the best cure. In the 18th century, doctors understood that they could no longer solve this ailment. A return home no longer treated these symptoms. Longing migrated. It did not redefine itself to the motherland. Nostalgia could not be found in the mind or the body and was termed the hypochondria of the heart. They turned to poets and philosophers for help. In the 21st century, it was considered as an incurable modern condition. The future was not something to believe in anymore. The utopian dimension of imagining was no longer directed at the future, but at the past, or sideways, lost in time and space. There's a saying that goes, the past has become more unpredictable than the future. But nostalgia can only exist if we view time as linear. It is most pertinent when the present is deficient. When the present cannot be trusted and the future is so uncertain, the past seems to be a comfortable place to go to. Then, to return to the past, we require objects, image, literature, or music. It's not always clear what nostalgic long for. Progress seems to exasperate nostalgia, just like globalization encouraged stronger local connections. Longing for community with a collective memory, a condition that seems to appear and reappear with big life changes and historical upheavals. Boehm continues to write about the contradictory nature of nostalgia, that it can take us to make us more empathetic towards one another, of course, but once we embark on replacing the longing with belonging, the apprehension of loss with a discovery of identity, the mutual understanding changes. So we can find each other in the longing, but we cannot find each other in the home, because the home that we return to is different. The promise to rebuild the home, to go back, something that receives much focus in many ideologies, make people desire emotional bonding over critical thinking. An imaginary home is put up as an actual home, or even a homeland, something to kill or die for. So nostalgia, we find, is quite common after revolutions, also velvet revolutions like we had in South Africa, a retrospective longing based on present needs, setting the stage for the future. It straddled individual melancholy, so individuals can hardly be nostalgic just in their own memory, that's melancholy, so it replaced that for a story of the collective. It sometimes tried to make sense of the impossibility of a homecoming. Why is nostalgia so seductive or manipulative, depending on how it is used? To understand this, there's a distinction between restorative and reflective nostalgia. Restorative nostalgia focuses on the home, to cross time, to restore the home, and can easily look like truth and tradition, while reflective nostalgia focuses on the longing and the ambivalences of this longing or belonging, and it questions the truth. Seen in this way, what I term conflict entrepreneurs can easily use restorative nostalgia in national, religious, and I will add ethnical revivals. Restorative nostalgia seeks to return to the origin and thrives on conspiracy. In contradiction to that, reflective nostalgia refuses to allow a single plot and focuses on details. So the nostalgia that I am interested in for this lecture is restorative nostalgia that often turns political, where the romance of nostalgia turns political and it's connected to a national building of sorts, and I mean national building in a wide way here. Native songs become purified and rewritten. Ernst Renan states that to forget, and I would venture to say to get one's history wrong, are essential factors in making of a nation. And in the case of institutionalized nostalgia, the stronger the loss, the more it is overcompensated with commemorations. The further we move from the past, the more it is idealized. So what do we do then with the nostalgia of the Afrikaner who benefited from a past of structures of oppression? We can hardly return to something like that. I know using the term Afrikaner is quite risky, as Afrikaners, of course, is not a homogeneous group, no matter how much the Afrikaner Bond and others would like us to believe. Jan Bosman, the chairperson of the Afrikaner Bond, lists the various identities of Afrikaners: Christian, Africans, Afrikaans, South African, from Africa, world citizen, here in South Africa for generation, part of a Western cultural community, economically active, part of various community family people. A TikToker recently told us that to be an Oranje type Afrikaner, you must be able to make koeksisters. The FRK lists religion respect for specifically older people and people in positions of authority, kuier in the sense of hospitality, community involvement, Afrikaans music, Afrikaans language, and land as characteristics. The Afrikaner ethnicity developed in the 18th century. It's centered around European ancestry, rural existence, farming abilities, Christian values, and the Dutch language. Two defining events are ingrained in the Afrikaner memory: the move to the interior in 1838, the Groot Trek, where Afrikaners colonized the Orange Free State and Transvaal, and the Anglo-Boer War from 1899 to 1902. The move to the interior, of course, led to the dispossession of indigenous people's land, and we also know now that the war was not only fought by Afrikaners and British people, it affected the whole country. Nevertheless, from these stories, a story emerged of Afrikaners as martyrs who withstood British rule and the harsh conditions of traveling inland. Despite these hardships, we are told they managed to till the soil, make it productive, and claim the land as their own. From the Anglo-Boer War, the narrative emerged of Afrikaners that was harshly afflicted people through the scorched earth policy and the concentration camps. A narrative of suffering and perseverance, a noble folk who, by the beginning of the 1900s, managed to disavow the European origins and could create a sense of an indigenized white ethnicity, unlike the British colonialists who were always with one foot in England. We have quite derogatory names for those people. South Africa became the sole nation, a national home of the Afrikaner, both physically and psychologically paid for in blood, sweat, and tears. During apartheid, Afrikaner identity became spatially organized, a national community, a folk, within a confined and exclusive geographical area. Now that there is no longer a nation state, there seems to be a return to cultural nationalism, and land plays a pertinent role in this. I do not wish to deny or minimize the hardships suffered, also not the hard work. It is also in my DNA. My mother will tell you the story of my great-grandparents who survived the Anglo-Boer War but returned to a farm that burned down, followed by a story of building it up again. But this is not the only story. I wish to complicate the narrative. I want to delve into this identity interrupted by the fall of apartheid and the nostalgia that this disruption invokes and how this affects the law, if at all, and land law specifically. Other Afrikaner characteristics became evident when delving the exclusionary mythology and victimhood. Afrikaners often clothe themselves in victimhood in response to change, and then merge with a lager culture. Afrikaners feeling threatened will form a lager to protect their identity. Of course, this is seen in general. With Gobodo Madikanzela, a psychiatrist, sees this returning to a lager as a form of nostalgia, no longer the longing of the return to a physical home or nation state, but an inner space of mental and emotional resonance. Not a yearning for the past, but the yearning for a more idealized psychological space of containment, the search for a simplified and stable version of the past. Thus, nostalgia aims to ensure a sense of continuity and identity for the individual and the collective when faced with a significant transition. She writes that from a psychoanalytical perspective, at the core of idealization is splitting, an intrapsychic mechanism in which contradictory thoughts, feelings, or aspects of the self are kept apart. And only one of these conflicting polarities is embraced or acknowledged. The idealization of the past produces only good aspects of all that represents the past, both in terms of self-representations and internal object representations. This splitting can be explained also in terms of the philosophy of the complexity theory, something that I will return to at the end, which offers two ways of survival in cases like this: survival through isolation and survival through justice. But before I get there, we need to take a detour to understand how the past influences our current understanding of land rights and the role of nostalgia in all of this. Which brings me to ownership stories. American scholars, Heller and Zalzman, interrogate the notion of ownership and the rules that lurk under the surface of the seemingly clear concept of ownership. They argue that the rules of who gets what and why are constantly shifting, with every choice producing winners and losers. They identify 6 maxims that justify the initial ownership of scarce resources, including land. They name it first come, first serve, so somebody was there first, therefore they've got ownership. Possession, somebody that can hold possession can be an owner. The labor theory, you reap what you sow. A rule of attachment, it's mine because it's attached to something that's mine. They also speak of ownership of body parts, which I will not do tonight. And the meek shall inherit the earth, so where they speak ownership through inheritance. They then explain that none of these are quite true. We often hold them as truths, but ownership is just a storytelling battle amongst either of these 6 stories. Property conflicts' origins lie in these competing stories. Everyone picks the story that supports their claims as the morally preferred claim to convince everyone else that their story is the only story. And while there are no natural or correct descriptions of how to frame ownership, the choices of how to solve this dilemma can be better or worse. So there's no correct answer. There are just better or worse outcomes. So my interest is in who makes these choices and how are these choices made? Because ultimately these choices end up in legislation and how jurists in general and judges in particular interpret the law. The relationship to land and the representation of this relationship is often held up as a justification, a starting point for the current claim to land rights in land and the protection of these rights. But they are actually the conclusion. So I will briefly touch on what I think are the most prevalent stories for justifying ownership and I will then show how literature, music, and fine art are used to continue telling these stories. Based on this, I will then argue that we need to examine these stories, however difficult they might be. We cannot merely use restorative nostalgia to erase the difficulty. Instead, we must consider how the different and often conflicting stories when interpreting the Constitution and applying the laws. But now I am a little bit ahead of myself. Let's return to the story of possession as a justification for ownership. Don't look at this slide now. So possession, the Afrikaner justification for land ownership, rests on mainly three of these stories. Possession, in the sense that physical control over the land is the focus, and physical attachment to the land makes it more valuable. If you take that away, then you need to pay more than the person did when they initially established the possession. One story is that possession was established through conquest. This is the story that land acquired through conquest is a valid way in international law to acquire land, at least until World War II. Often, in tandem, is the justification that the conquered people's cultural and economic inferiority justifies this imposition of foreign rule. This conquest was often brutal and destroyed more than people's claims to the land. It often also resulted in the loss of other property. In South Africa, there are a lot of accounts of how cattle, for instance, was also taken in the process. How should we then today go about the fact that current land holdings might be based on such injustices? Should we accept, as we are told, that the passage of time justifies current rights? Are we compelled to right the wrongs of dispossession instead? My colleagues who specialize in decolonial studies focus much on this, an area that I have only scratched at the surface up to now. The answer probably lies somewhere in between. The idea that subsequent landowners cannot be held liable for the original dispossession, and that current ownership does not per se freeze out prior claims. Possession through negotiation is the story of acquiring land through fair agreements. Do we believe the storyteller or do we believe the story in this instance? I have elsewhere delved into detail into the story of Piet Retief and Dingaan, as often when Afrikaner people are willing to have tough conversations on the issues of land with specifically government, the Piet Retief story is invoked to warn them about the untrustworthiness of people they converse with. I'm not going to go into detail here, but I can tell you that this story is relayed very differently by various people, various storytellers, each with their own interpretation, some of which undermine the veracity of the claim that the dealings were in good faith, or the understanding that a leader like Dingaan could legally make a deal to give away land on which a community lived. Interestingly, this is a problematic area that still persists today and which was recently criticized in the Inkonyama judgment in KwaZulu-Natal and the Supreme Court of Appeal. Other accounts state that at most, Dingaan could give away use rights and not ownership. According to this version, there simply was no agreement. If there was no agreement, there was no initial possession. Then we're back to square one. How should the law deal with this? The second story is, I owned the land because I worked for it, fruits of your labor. A Lockean idea that the labor of a man's body leads to a claim of property rights. Of course, what counts as labor is also qualified in this story. Unless the land is tilled to the highest possible use, the gift of the colonialists, there is no labor to speak of, and thus no property right. Ownership was only ownership if the blood, sweat, and tears turned land into farm units that were quite familiar to the European motherland. But if labor does lead to property rights, how does one explain the denial of rights of the many commercially successful black farmers in the early 1900s, or the current black farm laborers? There is no value-neutral way to justify one form of labor above another. It is not neutral, empirical, or uncontestable. In fact, we are contesting it in our daily conversations on land law. Ownership is a conclusion, it's not a fact. The last story is the one of "we were here first," which is perhaps more difficult to justify. It rests on the principle often employed in law that whoever is earlier in time has the stronger right. But being first is also not an objective fact. If this was so, the Khoi and San people should equally succeed in the claim of ownership. This idea of who is first is resting on a specific notion of how we define first. Is it those who first labor the land, conquer, use? What counts as first is often through the lens of, again, back then the colonialist thinking, not the indigenous people. The little look at the same things from different angles. Anne, your inquisitive Latin brain and your literary mind. You always have the right quote. If you have a problem, Anne's got a book that she will throw at you. Your inspirational teaching stories and your ability to extend tenderness to people when they are suffering, it makes me always reconsider my priorities. Then my aunts are here, Engela, Rieta, and I know Esti is watching from Stellenbosch. Engela is the second Oma in our house and the maker of great pompoen cookies. And Rieta is my dad's sister. She's the maker of great cheesecake, and she's always ready with a supportive WhatsApp and a link to my paternal ancestors. For that, I'm very grateful. To my friends from wherever you are joining, whether you are here in person today or online, thank you. I feel a little bit ambivalent about this online thing. It makes it great that everyone can be here, but it also means that everyone is not in the room here. But still, I'm very grateful for everyone who's, and it includes my friends and colleagues tuning in from Johannesburg, wherever else. I'm glad technology will join in, and I thank you for your support. This evening would not be possible if there was not, if the faculty and the university did not believe in me and have faith in my abilities. I want to mention Prof Stephen de la Harp, who encouraged me initially to apply for promotion, and for Dr. Murray, thank you very much for seeing that through. Thank you also, Dr. Murray, for everyone here tonight, and for the introductions and all the support. It is greatly appreciated. I'm truly blessed with wonderful supportive colleagues, a wonderful supportive faculty, and I appreciate every one of you who are sitting here in your red robes for making the effort to be here tonight. Then nothing would have happened if it wasn't for Sarita organizing it. So my social anxiety levels are fairly high. I'm sure my husband will attest to that, but Sarita will also attest to that. But Sarita really took most of the stress off my shoulders, leaving me only with a lecture to prepare. Thank you very much, Sarita. Okay, so I left the most difficult for last. I want to acknowledge the presence of the absence of my father. Initially, I wanted to play the song Likkie vir jou. However, every time I listen to this song, I do the ugly cry. And no matter how many times I listen to this song to get the ugly cry out of my system, the ugly cry doesn't get out of my system. So I will spare you the ugly cry, and I hope, so only the ugly cry, but I hope, but I do not want to spare you the remembrance of a person who had a profound influence on my relationship with the law. He's missed every day. And he is particularly missed in moments such as this. Ek weet. So no ugly crying, but with this I'm going to bow out, and I look forward